Hello, my name is Judy Watson. I am a business management student at Southern Regional Technical College in Thomasville, Georgia. I am elected to do my presentation on the Family and Medical Leave Act, otherwise known as FMLA, because I am employed with a local organization as a benefits coordinator, and tracking leaves of absence is part of what I do in that role. The Family and Medical Leave Act provides up to 12 weeks per year of unpaid, job-protected leave to eligible employees of covered employers for certain covered reasons that we will discuss later. While on leave, the employee's health insurance coverage must remain intact as if the employee had not taken a leave of absence. To be eligible for FMLA, an employee must work for a covered employer. The definition of a covered employer is a private sector employee with 50 or more employees working 20 or more work weeks in the current or preceding year, or a public agency, including government agencies, or public or private schools, regardless of the number of employees. To be eligible for FMLA, the reason for the leave of absence must qualify under FMLA guidelines. Qualifying reasons include the birth or adoption of a child, including time to bond with that child after the birth or adoption. Placement of a foster child is included in the reasons as well. A serious health condition of the employee or of a family member of the employee is another qualifying reason under FMLA. Finally, an employee or an employee's family members call to active duty, or caring for a family member who is a covered service member with a serious health condition also qualifies under FMLA. Employees must have worked for a covered employer for at least 12 months in the past 7 years, must have worked at least 1,250 hours in the last 12 months, and must not have previously exhausted his or her FMLA entitlement within the last 12 months to be eligible for FMLA. What is a serious health condition? A serious health condition is defined as a condition that renders the employee unable to perform the functions of his or her job. What family members are covered? A family member under the FMLA includes parents, spouse, or children. In some cases, a parent may be considered in loco parentis, where a child was raised by someone other than his or her biological parents. It is a violation of FMLA for employers to refuse leave to eligible employees who qualify for leave under the FMLA. It is also a violation of FMLA for employers to terminate benefits for individuals who are under the protection of FMLA. Employers cannot legally retaliate against employees who utilize their FMLA entitlement. Today we are going to look at a case involving an alleged FMLA violation. In July 2010, the plaintiff injured his back at work and was subsequently restricted from lifting more than 10 pounds initially, but the restrictions were eventually increased to 20 pounds. The employee worked within these restrictions, and Human Resources was aware and encouraged him to work within his restrictions. In May of 2011, the plaintiff requested FMLA due to anger management and anxiety issues. He was out until July and again took some time in August, exhausting his FMLA entitlement. In November 2011, the plaintiff re-injured his back and was counseled for absenteeism issues for being absent without receiving a doctor's excuse. Early in 2012, the employee suffered 2 seizures, causing him to pass out at work. In the spring of 2012, the plaintiff began to have suicidal thoughts, unbeknownst to the defendant. The plaintiff called his team supervisor and told her he was at the emergency room and he had a gun and was going to end it all. The team supervisor called in her superiors, who then contacted the plaintiff. The plaintiff told the superior that he couldn't take the pain anymore and he would not return to work. The company processed his failure to return to work as a voluntary quit. The plaintiff's girlfriend called to request the FMLA paperwork the day after he told them he was quitting, and was informed that he had quit the day before. Neither she nor the plaintiff disputed that his quitting had been voluntary. In the court case, the plaintiff argued that the company violated his FMLA rights and retaliated against him. The defendant motioned for summary judgment based on the fact that he voluntarily quit and that they could not have retaliated against him by discharging him because he had quit voluntarily. To prove an interference claim, the plaintiff must prove that he was eligible, that the defendant was a covered employer as defined under the FMLA, that he was entitled to leave under the FMLA, that he gave his employer notice of his intentions to take leave, and that the employer denied the employee FMLA benefits to which he was entitled. In this case, the employee voluntarily quit his job and therefore was no longer an eligible employee. Now he was entitled to leave under the FMLA. He quit instead of notifying his employer that he needed leave. If an employee voluntarily quits, they cannot maintain FMLA interference. The defendant in this case was able to prove that the plaintiff did indeed voluntarily quit, and therefore the defendant did not interfere with the plaintiff's FMLA entitlement. Because the plaintiff did quit voluntarily, he is not able to claim that he was discharged due to retaliation. Summary judgment was granted in favor of the defendant. As a benefits coordinator, I have learned to be familiar with the rules and regulations of FMLA. It is important that a company have policies in place that spell out an employee's responsibility regarding FMLA. I have learned that each individual case is different, but you have to treat employees consistently across the board and do not show favoritism. It is also important to document appropriately so that if questions arise in the future, you can remember what occurred more accurately. FMLA is a great benefit for employees, and when used appropriately, usually doesn't interfere with the company's ability to function for a limited amount of time. As with anything, the few who abuse the benefit may cause hardships on those who do not. So use your time wisely in consideration of others. Thank you for watching.